Hii nguvu ambayo anatumia sasa apigane na ufisadi katika serikali yake ya Jubilee. Hii nguvu anatumia sasa atumie kuboresha maisha ya watu wa Kenya. Mimi maizeni nakwambia, tumia nguvu leo, tumia nguvu kesho, tumia nguvu kesho kutwa, tumia nguvu mtondogoo. Msimamo wa Hassan Ali Joho haubadiliki kamwe. Nataka niwaambie hivi. Nataka niwaambie hivi. Uhuru Kenyatta alikuwa hapa Likoni na akasema ataninyorosha, ataniangusha, ataniangusha. Mimi namwambia Uhuru Kenyatta na nisikie vizuri. Mimi naogopa Mwenyezi Mungu, Mungu wa mbingu na ardhi. Mimi sitaogopa Uhuru Kenyatta. Tunaogopa kwa moja mzee. Tumia hiyo nguvu leo, kesho kutwa, lakini mimi nami naomba Mwenyezi Mungu wangu usiku na mchana, na niombe ile nguvu ambayo atakuonyesha mimi wa Kenya wa kuonesha tarehe 8 mwezi wa 8 mwaka 2020. I want to tell you, the leaders of Jubilee, you will never be God. You are playing godly.
Those are live pictures there from Mombasa, where Governor Hassan Joho has just left the Coast Regional headquarters, police headquarters, where he had honored summons to appear before the DCI over the forged KCSE certificate investigations in a rather dramatic fashion. The governor there, addressing his supporters who accompanied him alongside his lawyers, including Siaya Senator James Orengo. Back in Nairobi, the High Court has directed Parliament to enact the 2/3 gender rule within 60 days. High Court Judge John Mativo ruled that the National Assembly contravened the Constitution by failing to pass the law requiring that all elective and appointive positions be filled by not more than 2/3 of either gender. The court further ruled that failure by Parliament to enact the said legislation amounts to a violation of the rights of women and equality as well as freedom.
And Declaration B, and is hereby issued that the National Assembly and the Senate have failed in their joint and separate constitutional obligation to enact legislation necessary to give effect to the principle that not more than 2/3 of the members of the National Assembly and Senate shall be of the same gender. B, and Declaration B, and is hereby issued that a failure by Parliament to enact the legislation contemplated under Article 27(6) and 8 and 81B of the Constitution amounts to a violation of the rights of women to equality and freedom from discrimination and a violation of the Constitution. 3, a note of mandamus B, and is hereby issued directing Parliament and the Honorable Attorney General to take steps to ensure that the required legislation is enacted within a period of 60 days from the date of this order and to report the progress to the Chief Justice. D, it is further ordered that if Parliament fails to enact the said legislation within the said period of 60 days from the date of this order, the petitioners or any other person shall be at liberty to petition this court, to petition the Honorable the Chief Justice to advise the President to dissolve Parliament.
It's a happy day for the people of Kenya because, number one, it means our Constitution is alive and well. That you can try to suppress it, but you cannot kill it. And if you try to kill it, it will be impossible to bury it. Number two, we also learn a lesson that as citizens, our vigilance is key for the enforcement of this Constitution. Remember, Parliament has delayed the coming of this day, but to the extent that the groups that moved court have remained vigilant, this day has come.
Now, to help us understand better the impact of this ruling, we have in studio Bwana Steve Ogola, the legal counsel for the petitioners. Thank you, Bwana Ogola, for joining us. And we just need to understand, when it comes to separation of powers, can the court really direct Parliament to do anything?
Well, thank you, Fred. As you said, I'm Steve Ogola, the co-counsel, the other counsel being my learned senior, Mr. Ngola himself, and Advocate Business Ombola. Well, then coming back to the merits of this decision, this is a practical self-decision. The Constitution provides that if Parliament fails to pass such a legislation, then the court shall order and prescribe a specific time frame by which Parliament shall then enact that legislation. So for me, I find this decision as a practical sense move, and Parliament should move with speed to enact that decision, not just within 60 days, but even quickly. I mean, as soon as tomorrow.
Yes, but we've seen, because this is a political issue, we've seen even despite the insistence of both the president and the opposition party leader Raila Odinga that their members actually pushed through this law, it failed, and because it's up to individual members of parliament to decide whether or not to vote it through. What happens if Parliament fails to actually follow the court order?
First of all, to clarify, it's not a political issue per se. This is an issue of structural impunity seeping through to affect the implementation of the Constitution. The Supreme Court already held in 2012 that this legislation ought to be enacted within a period of 5 years, meaning 27th of August 2015. Parliament then exercised its powers allowed under Article 261 and extended that duration by 1 year. After that 1 year, Parliament failed to pass that legislation. So for me, it's a question of adhering to the Constitution, the political machination, the movement, the political goodwill, while they may be necessary, but also what you're insisting on